Hey, welcome to today's episode of the Law of Self-Defense. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you very much. That's greatly appreciated. And we're going to have a very interesting show today. We have some videos to share with you. One of a prankster pouring apparent gasoline, actually water, but apparent gasoline on the hoods of occupied vehicles. We have a second gasoline-related video of a woman who's confronted by a man in her vehicle while she's at a gas station. He gets shot. And I have a third bonus video I hadn't planned on covering today, but it involves 3 police officers attempting to make an arrest of a suspect outside a car, and they're completely inept at securing the suspect's arrest, probably for political reasons than reasons of incapability. And there's an important lesson in that for all of us, even those of us who are not police officers. So that's what we'll be covering today. And with that out of the way, let's dive into the intro for today's show. All right, so we do have, of course, a couple little housekeeping things to get out of the way. One is that we still have up our first class of our summer semester constitutional law course that is we're making available for free. So our con law class is part of our American law courses, where we provide law school level courses at a fraction of the time and cost of law school and without any of the political toxicity of today's law school environment. And our summer semester just started last week with constitutional law. This will be a 14-week semester-long constitutional law course taught by Professor Linda Deno, who's not only amazing, but you get to see how amazing she is because we're taking last week's class, the first class in that constitutional law course, and we're making it publicly available to everybody. So you can view it and get a sense of what you should expect to receive in terms of value from this constitutional law class. The second class in constitutional law is this evening. So I would urge you to take advantage of this. We're not going to have the class publicly available for very long, but while we have it up, now would be the time to take a look. And you can learn more about that at AmericanLawCourses.com/conlaw. Also, another housekeeping change of policy here at Law of Self-Defense I should make everyone aware of, and that is that we are as you know, probably about 50 to 60% of our weekly content is members-only content. We did a members-only show just yesterday, for example, on Daniel Penny's interview with the New York Post. We spent over an hour talking about that, the legal implications, the strategy implications, the political implications, how smart his lawyers were in the manner in which they orchestrated that interview with the New York Post. Very, very well done. Lots of valuable lessons to learn there for all of us who are concerned that we may someday have to use force in defense of ourselves, our family, or our property. But yesterday's show was a members-only show. You can see it only on the Law of Self-Defense members dashboard. Whoops. Didn't mean to do that. Also, moving forward, we are only going to be addressing comments and answering questions from our Law of Self-Defense members in the member dashboard. So that is the only place we'll be taking questions moving forward. We have in the past been taking questions from YouTube as super chats and Rumble as Rumble rants, but frankly, it's too cumbersome for me to be flipping back and forth between the social media platforms. So don't bother with super chats unless you just want to give me money. That's fine. Don't bother with Rumble rants. I won't be reading them moving forward. So if you'd like a question answered or you'd like a comment addressed, you need to do it as a Law of Self-Defense member. The good thing is membership is dirt cheap. You can become a trial member for 2 weeks to try it out for only 99 cents. Pretty low risk. After the 2-week period, if you stay a member, and virtually everybody does, membership's only about 30 cents a day, folks. 30 cents a day, less than $10 a month. If this content isn't worth 30 cents a day to you, I don't know why you're here. Plus, you would double the amount of content you get as a Law of Self-Defense member because you get access to the members-only content as well. You can try out that trial at lawofselfdefense.com/trial. And that's where we are with all of that. In fact, let me pull that up and put it at the bottom of the screen for the duration of today's show. Come on. It's here someplace. I know I have it. Well, I don't have it. That's terrible. Let me set it up right now. Law of Self-Defense trial membership. 99 cents. Law of Self-Defense.com trial. There you go. Lawofselfdefense.com/trial is where you become a Law of Self-Defense member for 30 cents a day. Folks, you got that kind of spare change rolling around in your car. I know it. We all do. That's where you need to be if you enjoy this kind of content. Let's see. Anything else? Anything else I need to cover? Let's make sure we're streaming where we need to be streaming. The member dashboard is working correctly. YouTube is working correctly. Twitter. And obviously today is an open access show. Unlike yesterday's and unlike tomorrow's, which will be members only again. Okay, awesome. So what do we have today? Today we have a number of videos. One is the prankster pouring gasoline on occupied vehicles. So let me pull that one up first. He appears that he's actually pouring water. But it's from a gas can, and he's telling the people inside the vehicle that he's going to set their vehicle on fire. Pretty nice, huh? These pranksters, this is a particularly dangerous thing to do in the United States when many people are lawfully going about their day armed. In fact, this prankster runs into one of those armed American citizens. So let's play the video and then talk about it. Here we go.
Come on, man. Burning your car down, bro. Fuck your car, man. Over. All of this. Yeah. Uh-huh. Why you want to do it? Come on, man. Come on, bro. Hey, water. Kanye 2020. Do what?
Hard to see.
Be water, partner.
He's got a gun in his hand.
Dead son of a bitch. You stay out of this. Yeah, I don't want to do that. You almost died, you stupid son of a bitch. Fuck you, pussy.
All right, so two different events here. We have the second one here. The gentleman with the gun in his hand after the apparent gasoline's been put on his vehicle. That's this gentleman. And of course, we have the initial event. The gasoline's put on the hood. This gentleman doesn't present a weapon. But of course, it's not just his car that's threatened here. It's actually himself when he's pursued down the parking lot by the gentleman with the gasoline. And it's not just the apparent gasoline that's being poured on the vehicle. We can hear that the prankster also appears to be flicking a lighter. Let's watch this portion again.
Come on, man. Burning your car down, bro.
So there's the threat of burning the car down and the overt physical act.
Yeah. Uh-huh.
There's the lighter.
Why you want to do
Click,
it?
click. So what can be done here? What can be done? Can you use force to defend your property? Can you use force to defend yourself? Can you use force to defend other people? And the answer, of course, is yes. It all depends on the nature. the nature of the threat and the nature of the force that you're using. Let's see. So, what do we have here first? First, we have the prankster apparently pouring gasoline on the hood of the car and threatening to set the car on fire. Now, if the car is occupied and you set the car on fire, can that reasonably be perceived as an imminent deadly force threat to the people inside the vehicle? Absolutely. No question about that. Doesn't change when this gentleman steps out of his car. So now if the car is set on fire, is that still an imminent deadly force threat to this person, this gentleman, the owner of the car, presumably, or only to the vehicle? That would be the legal question. Now, remember, deadly force includes force readily capable of causing death or serious bodily injury. If there's effectively a large puddle of gasoline a couple of feet from you and it's lit on fire, can that cause serious injury? Perhaps. I don't know. That would be the question that would have to be answered. The question is, if it is capable of causing death or serious bodily injury, even in this circumstance, when the guy's no longer in the vehicle but standing beside the vehicle, is there a reasonably perceived imminent threat of serious bodily injury to him if the gasoline's lit on fire? If the answer to that is yes, then he's privileged to use deadly force in self-defense to prevent the gasoline from being ignited. What if it's not just this gentleman in the car? What if there are other people in the car and they're still in there? What if there's a child strapped into a child seat in the back of the car? So it would be cumbersome and time consuming to attempt to remove the child from the car. Again, the question is there a reasonably perceived threat of imminent death or serious bodily injury to the owner of the car or any other innocent person? If the answer to that is yes, this gentleman would be privileged in using deadly force in self-defense to prevent the gasoline from being lit. The risk, of course, is that we don't know what the answer to that question might be, depending on the nature of the question, because it's not this gentleman's determination of that risk that actually controls his legal fate. It controls his use of force decision-making. He's got to make decisions in the moment. He's making those based on his perceptions of the threat, his reasonable perceptions of the threat. But of course, what controls his legal fate is the judgment of other people, of police who may respond to the scene, of prosecutors who read the investigative report, of judges who make decisions about what evidence may be admitted or not admitted, what law will be instructed to the jury. The jury makes the ultimate call on whether or not this man's perception of the threat was a reasonable perception. That's why there's always a risk. The moment you get involved in that confrontation, there's always a risk of being convicted because it's not your judgment that controls your legal outcome. It's the judgment of other people, maybe badly informed people, maybe politically motivated people, maybe activists. I mean, here we have, actually, it's kind of difficult to tell this guy's race, but let's presume he's white and the prankster obviously is black. Is that going to introduce a racial dynamic? Is Benjamin Crump going to show up? Is Al Sharpton going to show up, claiming that this poor kid who was just turning his life around, all he was doing, you can't kill someone for pouring water on your car? That may sound ridiculous, but if you've seen us cover any of these cases, you know those are exactly the kind of ridiculous statements that these activists in the racial grievance industrial complex make all the time. I mean, you would think with the Daniel Penny, Jordan Neely case, that Penny murdered Neely for the crime of being a Michael Jackson impersonator. Of course, that's ridiculous. But again, those are the kinds of narratives, how as ridiculous as they are, that are propagated behind these cases. So now, of course, what if we were in Texas? Texas, because we have a unique provision there for the use of deadly force in defense of property. Let's set aside the defense of persons risk. Let's presume that once this gentleman's out of his car, there's no one else inside the vehicle. Let's presume, for purposes of discussion, there's no credible, reasonable perception of an imminent deadly force threat to persons. Let's presume the only credible, reasonably perceived threat is to the vehicle. Obviously, if you set the vehicle on fire, it would harm the vehicle. Well, in Texas, of course, Texas is the only state that has a legal provision allowing prospectively for the use of deadly force in defense of personal property. And a car, an unoccupied car, is personal property. And that is Texas Penal Code 9.42. So let's take a look at this. 9.42, deadly force to protect property. First, of course, you have to meet all the conditions of using non-deadly force in defense of property, which would be section 9.41. So be sure you read that first. But in the interest of time, we'll presume those conditions have been met. So a person is justified in using deadly force against another to protect land or tangible, movable property, which this car would be if it's unoccupied. There's no one else left inside the vehicle. To prevent the other's imminent commission of arson. Is this arson? Looks like it. Burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime. So this would certainly qualify as criminal mischief. Damage, mischievous damage to personal property. That's criminal mischief. But it would have to be under 9.42 during the nighttime. This is obviously not during the nighttime. So even under Texas 9.42, it would have to be the arson of the vehicle rather than the simply the damage to the vehicle. The fact that this was fire, as opposed to the prankster were hammering on the hood with a hammer. Obviously not arson, clearly criminal mischief, but not taking place during the nighttime. By the way, arson generally is considered, although we think of it as a threat to property, you're setting property ablaze, is invariably considered a threat to persons, at least when we're talking about occupied dwellings, occupied structures, because of the threat. Fire races through structures. It's not controlled. So it's an implicit threat to anybody inside the building, adjacent buildings, and the same would be analogous to the car. So the car catches on fire. Is it likely in a crowded parking lot to set other vehicles on fire? To be a threat to, maybe there's people in those other vehicles, even if there's not a person in this particular vehicle. So a definite prospective risk. Then, of course, we have the second part of this scenario, where the prankster is chasing the car owner down the parking lot with the can of gasoline and presumably still in possession of his lighter that we heard earlier. This is no longer a threat to property. This is a threat to persons. If you pour gasoline on somebody and set them on fire, are you creating a likely risk, threat of death or serious bodily injury? Of course you are. So would this gentleman have been privileged in simply drawing a pistol and shooting this prankster dead in the parking lot, believing that it was gasoline and a lighter he was being pursued with? Unquestionably. Unquestionably. An imminent, reasonably perceived. Now, of course, is it actually a deadly force threat? No, there's water in the gas can, right? It's not actually gasoline. Does that matter in terms of the legal justification? Not a bit. Not a bit, because it's being presented. It's creating the manner in which the gas can is being used is explicitly and intentionally being done so as to create in the minds of the victim here a reasonable perception that it's gasoline. It's in a gas can. It's being claimed to be gasoline, a flammable substance. I'm going to set your car on fire. There's the verbalized threat to do that. There's the overt physical acts of pouring the purported gasoline and flicking the lighter. This would be a clear-cut case of a justified use of deadly defensive force here. And there would still be a risk of conviction, right? There's still the risk of someone like in Al Sharpton saying, well, you can't shoot someone dead just because they pour water on you. So the good news, of course, is that in the event that there were to be charges, it's an adversarial process. You get your say too. Just make sure you have competent legal counsel to do an effective job in presenting your narrative of reasonable self-defense, despite the fact that there was no actual threat of death or serious bodily injury, because it was only water. You're not required to make perfect decisions in self-defense, folks. You're required to make reasonable decisions in self-defense. Mistakes of fact, like believing this was gasoline when it was actually water, mistakes of fact are permissible. It's still lawful self-defense if the mistakes are reasonable mistakes. Now, mistakes of law are not forgivable, right? Ignorance of the law is no excuse. When you're facing charges, when you're going to court, nobody cares what you thought the law was, what you heard about the law on the internet, what your retired cop buddy down the street told you you'd be permitted to do in self-defense. Nobody cares about that, or defense of your property. Nobody within the courtroom or considering charges cares what your mistaken belief of the law was. All they care about is what the law actually is, which means it ought to be pretty important that you know what the law actually is. This is the pursuit with the gas can, of course. And a pretty good way of knowing what use of force law is, folks, a very, very good start would be to take advantage of our free book offer, Law of Self-Defense Principles, a real physical book. Check it out on Amazon. 5-star reviews, well over 1,000 reviews there, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. We only ask that you cover the shipping and handling of getting the book to you. We'll give you the book for free. Law of Self-Defense Principles. You can get the book at lawofselfdefense.com/free book. Lawofselfdefense.com/free book. Easy enough to remember. Okay, let me take a look at the Law of Self-Defense member questions. Again, remember, moving forward, folks, don't bother with the super chats or the Rumble rants. I'm not looking at questions or comments on YouTube or Rumble. It's too cumbersome. If you'd like me to consider your comments or answer your questions, they need to be presented in the Law of Self-Defense members only chat on the members only dashboard. And again, you can become a member right now for just 99 cents at lawofselfdefense.com/trial. Okay, let's see. Lots of chatter, lots of commentary. Tony says, Andrew, I will most likely be beginning your instructor program soon. Well, that's great. The instructor program is extremely popular. I put it there at the bottom of the screen. This is our, the Law Self-Defense Instructor Program. It's intended for self-defense firearms instructors to give them a really robust education in self-defense law. If a law school had a semester-long class on use of force law, this is what it would look like. It's roughly 14, 15 hours of instruction. More than that, actually. I think it's 14 or 15 classes, and each one of those is at least an hour long. It's quite rigorous. There's homework, there's reading assignments, and there is a final exam at the end for certification. And you do need to pass the final exam to get certified. Now, that said, anyone who's been diligent in going through the course materials should have no trouble passing the final. We designed the final to be readily passable by anyone who's done the work. In the unlikely event, it's very rare. Occasionally, someone doesn't pass it the first time. We just talk them through whatever errors were made, and invariably they pass the second time. So I don't want you to think the final is some kind of gotcha at the end. But we do want people to know that if you have that Law of Self-Defense instructor certification, the instructor program certification, it's because you actually know your stuff, and we know you know your stuff because you passed the final exam. So any of you who might be interested in a course like that can learn more at lawofselfdefense.com/instructor. Let's see. Back to the questions. Jeffrey says, next month I'm taking MAG 40. MAG 40, that's great. So that's Massad Ayub's week-long course. The reason I do the law I do, use of force law exclusively, and to my knowledge, I'm the only lawyer in the country who does use of force law exclusively. I don't have a generalized criminal defense practice. I just do self-defense, defense of others, defense of property. That's it. No DWIs, no shoplifting, nothing else. The reason I do this, I have this focus, is because I took the equivalent course from Mas Ayub of MAG 40 back in 1996. Back then, he called it Lethal Force Institute 1, but it's basically the same week-long class. And it blew my mind because I learned so much in that week-long class with Moss that we never were taught in law school, that it was a completely mind-blowing experience. I strongly encourage everybody to take any course Moss teaches, but particularly the MAG 40 course. And MAG stands for Masad Ayub Group. So if you just Google that, and you'll get to the course just fine. George asks, I would love an app, like a law self-defense app. We have discussions about it internally all the time, folks. We're not that technically sophisticated. We really need to find a partner to work with who can do that for us. If you have any recommendations, send them our way to support@lawofselfdefense.com. Put in the subject line forward to Emily, and I'd love to have an app too. Oh, someone says the license plate in the video is Texas. That could be. Arson is generally a forcible felony because of the implicit threat to human life. Let's see. Questions. Just scrolling through the questions here, folks, before I get to the next video. Clay says, howdy from Houston. I know the man with the truck. He's still upset that they pranked him like that, and this was the first time he's ever pulled his weapon in decades of carrying. Yeah, he should be upset because he came damn close to killing somebody. Almost certainly lawfully, with more than sufficient legal justification. But no normal person wants to have to kill another person. So, of course he's upset. And of course, no matter what your justification is, I always caution, if we have to put you in front of a jury, there's a 10% chance you get convicted. That's the noise in the system. Even here, it can happen. So this prankster put this guy at a lot of risk, put himself at a lot of risk of dying, of course, but also put the truck owner at a lot of risk. Kyle writes, none of the tests in any of the classes are hard if you pay attention. That's true. We don't design the tests to fail people. We just need to affirm for our own purposes that you actually, you didn't just turn on your computer and walk away. By the way, the instructor program is entirely streamed online. So you watch it on your own schedule. So you don't have to worry about the timing of the classes. You could, I guess, in theory, go through the whole thing in a week. We don't recommend that. We recommend that you do one class a week so you have time to absorb the content. But you do take the instructor program course at your own pace. All right, that's all the questions for the first video. Let's get now to the second video. This is a woman in a gas station. And she has a confrontation with a man. Now, there's a lot of facts about the circumstances we don't know here. We don't know why this confrontation started. We don't know if there's any relationship between these people. So we have to make some presumptions when we're looking at the video. I'm going to presume there is no relationship. This is just two strangers having an angry confrontation for undetermined reasons. I'm also going to presume that this woman didn't do something to initiate this confrontation, that she's not the initial physical aggressor in this fight. She's substantially smaller than the gentleman she'll have the confrontation with, who happens to be a relatively large black male. And the woman's this is her silver car here. She'll be getting into it. So let me go ahead and start this video. It's only about 29 seconds, and we'll see what we have to see. Okay, so that didn't work out well for him. We kind of go through it step by step. Here's the woman. She's getting into her car. We hear angry shouts. I can't really understand what's being said. I presume the man's shouting at the woman for some reason. Maybe he cut her off. Maybe it was a offensive look. I don't know. But he's clearly upset. She gets in her car. She closes the door. he opens her door. Now, we don't know what state this is in, but in most states, if you're it's an occupied vehicle, you're inside your vehicle and someone forcibly enters the vehicle, that would trigger a legal presumption that you're reasonably perceiving their forcible intrusion as an imminent. You're reasonably perceiving it as an imminent deadly force threat. Also, in many states, there's a second legal presumption that it's presumed that they are there to commit a forcible felony upon you. Now, question is this really a forcible entry, merely opening the door? I would suggest it is, because the reason we have the forcible requirement, so typically these legal presumptions that are triggered in the defense of highly defensible property, like a home, a business, an occupied vehicle. An unoccupied vehicle is just personal property, but an occupied vehicle is often treated as highly defensible property, much like your home, much like your castle. The reason it's generally required that the entry be unlawful, so they don't live there, they don't have permission, they don't have license to come in, they're there unlawfully, and that the entry be forcible. Typically, that requires that they broke something to get in. And why do we have the forcible requirement? We have the forcible requirement because we're concerned about an innocent intruder. An innocent intruder is someone who's not there lawfully. They don't have permission to be there. They don't have license to be there, but they entered without malice. An example might be a repairman who's sent to the wrong address. So he's told, hey, the people at this home, they need their whatever dishwasher repaired. They can't be home. They have to be at work, but they're going to leave the back door unlocked so you can get in and repair the dishwasher. And then they give the repairman the wrong address, and he goes to the wrong house. Sure enough, the back door is unlocked and he walks in. He's unlawfully present, but he's not there to do anything bad. It's an innocent intrusion. He's not there with malice. And the law doesn't want these legal presumptions that he's there to commit a violence upon someone to be triggered if it's an innocent intrusion. And the legislatures address that by adding the requirement of not just unlawful entry, but forcible entry to exclude the innocent intruder, the non-malicious intruder. But think about the policy behind that. What we're concerned about is an innocent intrusion. And there can't be an innocent explanation for why you broke something to get in, right? But what if there's other evidence that also eliminates the possibility of an innocent intrusion? What if it's unquestionable that this was not an innocent intrusion, that the entry is being made with malice? I would suggest that satisfies the underlying policy behind the forcible entry requirement, even if nothing's broken to get in. Right? The forcible is to screen out innocent intrusion. If the person coming in knows that they're entering not without license, if they know they're doing it, it's not an innocent intrusion when the policy demands for forcible entry have been met. And I would argue under this circumstance, a very angry man opens the door, gets in this woman's face inside her vehicle, and then, of course, punches her, which absolutely removes any doubt about whether or not it was an innocent intrusion. This is not a case where he has a very similar looking car and he hops into the passenger seat thinking it's his own vehicle. That's not what's happening here, right? This is an aggressive entry into the vehicle, even though he doesn't break anything to get in. So were I defending this woman, I would say absolutely. At this point, he jerks open that door. He's committing a forcible, unlawful entry into her highly defensible property, her occupied vehicle, and that creates a legal presumption that she has a reasonable fear of imminent deadly force harm from him, imminent unlawful deadly force harm from him, and that really gives her, satisfies pretty much all the elements she needs to be justified in using deadly defensive force. Remember the 5 elements of self-defense, the building blocks of any claim of defense of self or defense of others: innocence, imminence, proportionality, avoidance, and reasonableness. This legal presumption that when faced with an unlawful and forcible intruder into highly defensible property, it's presumed legally that you have a reasonable perception of an imminent, unlawful, deadly force threat against you. Just look at the words in that sentence. It's giving you imminence. It's giving you proportionality, that the threat is deadly in nature. It's giving you reasonableness. Now, there's the element of avoidance, which has to do with whether or not there's a legal duty to retreat, but you're covered by that under the Castle Doctrine anyway. And in any case, retreat's only required if it's possible to do with complete safety. It doesn't seem likely here. And of course, innocence is kind of baked into the cake already. If you're dealing with a forcible, unlawful intruder into your highly defensible property. So basically, you're given all the elements. Now, we do get a little more complicated here. Of course, the gentleman throws the punch. So I would suggest every moment here, from when the door opens, certainly when the punch is thrown, that this woman in the car, absent some unknown information that might change the analysis, small changes in facts can result in big changes in legal outcomes. But based on only what we can see here in the video, that she would be legally justified in using deadly force to defend herself against this attack. But remember, we talk about the requirement of imminence. And by the way, this little cheat sheet, folks, we make available for free. If you don't understand these 5 elements of self-defense, you can't possibly understand the law of self-defense. You can get this cheat sheet. It lists the 5 elements, a brief description of each. It's just a PDF download. You can get it at lawofselfdefense.com/elements. Get it for free. But one of those elements is the element of imminence, meaning the threat you're defending yourself against is either in progress or immediately about to occur. It's not a past threat. It's not a future threat. And that imminence can be thought of as a window that opens and closes. Before it opens, you don't yet have an imminent threat. When it opens, you are facing an imminent threat. But then the window can close, right? Threats don't exist forever. And once the threat no longer exists, you no longer have the element of imminence. You no longer have a legal justification of self-defense. So does the element of imminence end when the car is now driving away? Is he still an imminent deadly force threat to her at this moment? I would suggest not. I mean, he doesn't have a projectile weapon in hand. He doesn't have a gun in hand. We have no evidence to infer that he has a gun. He engaged in a, contact weapon attack, the fist. And so I would suggest the window of eminence is closed. If this woman just continues driving away and she decides to shoot backwards at him as she's driving away, that would look sketchy as hell to me, because the threat is closed. Then the car stops. This gentleman looks like he dropped his phone or something when he punched her. Hopefully he broke his phone. He picks up his stuff. The car stops. And the door opens. She's opening the door now. So what's happening here? Well, we'd have to talk to her, right? What's in her mind that's happening here? Is there an explanation consistent with innocence for her stopping the car and opening the door? Maybe she decided, you know what? This guy just punched me. I want to charge him. I'm going to get a picture of him that I can show to the police when I file charges. That would be an explanation consistent with innocence for why she stopped the car, opened her door. On the other hand, maybe she decided, you know what? This guy just punched me. I'm going to shoot him, even though I don't have to anymore. You don't get to punch me and just walk away. So I got my gun out of the glove box. I'm going to stop, open the door. I'm either going to shoot him where he stands, or if he approaches, I'll shoot him as he gets closer. That would be an explanation not consistent with innocence. Right? That would look like she's now a deadly force aggressor in a second fight. Now, of course, the man stupidly manages to complicate even this by not getting shot where he stands, but by advancing on the car again. He's already punched her. He's substantially larger than her, so there's a disparity in size argument there. And I have a bonus video for you that I didn't promote for this show that illustrates the role that disparity in size, disparity of numbers can play in a confrontation. And we already know he's willing to lean into the car and punch her, right? Enter that highly defensible space again. And this, of course, is where she actually shoots him. Is this defensible? Well, it's much more complicated than if she shot him here, because more things have happened. She could have just driven away, right? Call the police. Now, of course, she's a woman. He's a large male. And when we talk about fists, normally I talk about traditional fist fights not being treated by the court as a deadly force confrontation, even though we know fists can and do kill people, right? Single punches can and do kill people. Rarely is the problem. As a percentage of the total number of punches thrown, it's relatively rare, very rare, for death or serious bodily injury to result. So it's invariably going to be treated by the courts as non-deadly force, attack against which only non-deadly force can be used unless there are aggravating circumstances. So the non-deadly force nature basically presumes that the two people throwing punches are of similar size, strength, and fighting ability. But what if that's not the case? What if one is substantially larger than the other, or stronger than the other, or has an exceptional fighting ability the other doesn't have? Then they're not evenly matched anymore. Then the punch being thrown by the larger, stronger, more fight-capable aggressor, person, participant, may be of a nature that it can readily inflict death or serious bodily injury to the victim, the smaller, weaker, less fight-capable victim. And that could make it a deadly force confrontation, even though it's just a fist. And those factors, smaller, weaker, less fight-capable, tend to be baked into the cake when the aggressor is a large male and the victim is a much smaller female. So that would be the argument you would make on behalf of the woman, even here when these shots happen. By the way, if she calls 911, the police respond, what is she going to tell the cops about what her motivation was when she stopped the car? Because there's a explanation consistent with lawful self-defense, that she was just trying to get a photo of him she could share with the police. And there's an explanation inconsistent with lawful self-defense, that she was pissed and wanted to shoot him because he'd punched her a moment before. You think it matters which of those explanations goes into the cop's investigative report that goes on to the prosecutors? It sure does. You think it might pay to know what to say or not to say when interacting with the police in the aftermath of a use of force event? Yeah. What happens if she doesn't call the police? Then she doesn't have to talk to them, right? Unless, of course, the cops have her license plate number, as they would, because this has been caught on camera. And then you have the problem, the dilemma of, are you going to be the complainant, the person who calls the police to complain, or are you going to be the respondent, the person the police have to call? Because from the initial investigative perspective, it's basically presumed that the complainant is the person against whom something wrong has been done. That's why they're calling the police to complain. And the respondent is presumed to be the person who did the wrong thing. Now, those aren't presumptions that carry all the way to trial. At trial, you're presumed innocent until proven guilty beyond a reasonable doubt. But those are presumptions that can greatly shape how the event is investigated and how the investigative report is framed, and the kind of building blocks available to a prosecutor to attempt to overcome an anticipated claim of self-defense. Because all the prosecution has to do is not overcome your claim of self-defense in its entirety. The prosecution only has to disprove any one of the required elements of self-defense, any one of them, and your legal justification collapses entirely. Okay, now let's take a look back at the member questions. Remember, moving forward, we're only taking questions and addressing comments from our Law of Self-Defense members. Become a member right now for just 99 cents at lawofselfdefense.com/trial. That's a 2-week trial membership, 99 cents, folks. And if you stay a member, and virtually everybody does, standard Law of Self-Defense membership's only about 30 cents a day, less than $10 a month. You get all our content, so you get double the content that you get as a non-member. And it's the only way to get your questions and comments addressed during the live show. We're not doing the super chat or Rumble rant thing anymore on YouTube or Rumble. Okay, let's see. Clay says he opened the door for this second video, forcible entry. That's how I would characterize it. Clearly, if he had say, by the way, should she have locked the door if she believed she was about to be in a confrontation, compelled him to break something to get in? Would that be helpful to her narrative of self-defense? And by the way, a lot of people don't want to break stuff. right? You cut up your hand. It's another step. It's an escalation. By the way, that escalation, is that useful as evidence for the defender in evaluating whether they're facing a deadly force threat, that the person was willing to break the window of the car to get at you? Of course it is. Glass inside the vehicle, it's unambiguous evidence of the forcible entry. So anytime you can, lock, secure your highly defensible property and compel the other person to break something to get in, you've stripped away any ambiguity from the scenario. Tony asks, what about imminence and the reasonableness of just driving away from the prosecutor's view? Yeah, I would expect the prosecutor to ask, well, why didn't you just keep driving away? And that explanation to that question is going to be pivotal in whether or not it's perceived as the shooting itself is perceived as a lawful act of self-defense, or whether it's going to be perceived as her either being the initial aggressor in the second fight after she began driving away and stopped the vehicle, or her accepting a mutual combat invitation and thereby losing self-defense that way. Kyle says the car could have stalled. That could be another reason, right? Consistent with innocence, why she stopped the car. It could be that she was immediately on her phone trying to call the police and then fumbled her phone and dropped it and wanted to pick it up to continue calling the police, calling 911. And so, it would be not unreasonable to, if you dropped your phone while you just started moving, to momentarily stop your car to pick up the phone. Maybe that's her explanation consistent with innocence. Nathan brings up a great point. Yeah, I meant to address this and I forgot. With the first video with the gasoline prankster, he says, even though legal analysis is the goal here, it prompts me to hope I have quick enough presence of mind not to fire my firearm in close proximity to gasoline. That's a real concern, right? If you've only fired guns in the daytime or well-lit circumstances, you may not know there's a lot of flash that comes out of the muzzle of the gun, some more than others. But the shorter the barrel in the handgun, for example, the more concealed carry friendly the handgun might be, we might say, the more likely you are to get flash out. And of course, if gasoline's been poured all over the hood of your car and then you're shooting across the hood through the fumes, which is actually what ignites, right? Not the liquid gasoline, but the fumes. Could you expect the gasoline to catch on fire? It seems likely. Would it be unreasonable for you not to think of that in the heat of the moment? To think, I got to stop that guy with the lighter. The lighter will definitely set it on fire. So it's a question of what kind of decisions are you making under stress, right? The U.S. Supreme Court has said a detached reflection cannot be expected in the presence of an uplifted knife. Well, that's what we're dealing with here. Right. So the reality that we might make imperfect decisions under the stress of a life-threatening attack, the time pressures, the risks of a life-threatening attack, that's taken into consideration by the jury. So the prosecutor would argue, hey, that gasoline would never have caught fire at all, but for you firing the shot. Well, you weren't firing the shot in a vacuum. You were firing the shot because you were compelled to do so by the conduct of that other person. Michael asks, question, if she's in a state that doesn't require avoidance, so she's in a stand your ground state, does she have to drive away or could she take action without driving away? Also, if she's in a state that requires trying to avoid, is driving away a fully safe way to escape and required? So in a duty to retreat state, if you have a completely safe avenue of retreat, you're required to take advantage of that before you can use deadly force in self-defense. Fair enough. Now, it has to be completely safe. You're not required to increase your jeopardy. It has to be a practical avenue of escape, not just some hypothetical avenue of escape. Here, for example, when she's getting punched, would she have had a clear, completely safe opportunity to drive away? Well, maybe not. Maybe she'd have to put the car in gear. Maybe she'd have to start the car. Who knows? And it's hard to do that while you're getting punched, right? You have to defend yourself from the punches right now. If the car's on and in gear and all she has to do is step on the gas, would we argue that's a completely safe avenue of retreat? Perhaps. Prosecutors often do. One scenario in which a lot of defenders get in trouble in duty to retreat states is exactly this one, where you're in your car, it's in gear, And all you have to do is take your foot off the brake and step on the gas pedal, and you could, with complete safety, retreat from the fight. But instead, you shoot the person. Very, very common scenario where people lose self-defense because they lose the element of avoidance in a duty to retreat state. Now, of course, once she's advanced her car and the door's closed and she could just drive away, and the gentleman is not in that moment any longer an imminent threat even of punching her, does she then have a completely safe avenue of retreat? I would argue yes. All she has to do is continue on her way. So and then when she stops in a duty to retreat state, that really opens the door up to the prosecution. You'd need a damn good explanation for why you stopped your car. Now, they exist, right? Oh, I wanted to take his photo so I could show it to police. But you'd better know what it is you need to be saying to not completely undermine your claim of self-defense. And I would caution, even in a stand your ground state, most of the stand your ground states, and there's 39 of them, and about 30 of them are what I refer to as soft stand your ground states. So in the soft stand your ground states, you don't have a legal duty to retreat before you can use deadly force in self-defense, but the prosecutor is allowed to argue to the jury, ladies and gentlemen of the jury, sure, this defendant didn't have a legal duty to retreat. We're a proud stand your ground state. There is no legal duty to retreat, but he could have safely retreated, and a reasonable person would have safely retreated rather than take a human life. And reasonableness is one of the elements of self-defense. And if you conclude that this defendant's failure to retreat was an unreasonable decision, he's lost the element of reasonableness, he's lost self-defense, and you must convict. They're allowed to make that argument. It's kind of a backdoor attack on a failure to retreat by going through the element of reasonableness instead of going through the element of avoidance, which avoidance is not a required element. It's legally waived in otherwise lawful cases of self-defense in a stand your ground state. There are about 9 states, stand your ground states, that I refer to as hard stand your ground states. Texas is an example. Ohio is an example. And there, the jury's instructed that they're not even allowed to consider the possibility of retreat in determining the reasonableness of the defensive force. So in the hard stand your ground states, avoidance is really off the table in otherwise lawful cases of self-defense. In the majority of stand your ground states, the soft stand your ground states, the prosecutor still has this backdoor path of attack because of a failure to take advantage of a completely safe avenue of retreat. By the way, whether or not a path of retreat is completely safe, that's a fact question, right? That's going to be decided. It's not your judgment of whether or not the purported avenue of escape was completely safe that's going to control your legal outcome. It's the judgment of the jury that's going to control. If they decide you had a completely safe avenue of retreat, then for legal purposes, you had a completely safe avenue of retreat. That's what's going to control your legal outcome. Kenneth says, question, would a good reason for stopping the car be that she couldn't proceed because she couldn't see very well since she just had her nose flattened? Yeah, sure. That would be another explanation consistent with an innocent reason for stopping the car. If you've ever been punched in the nose, you know it's very common for your eyes to tear up, for example, or just, blood running out of your nose. She might see blood running down her shirt and be shocked and stop the car for that reason. Lots of reasons she might stop the car. Maybe she opened the door to call for help. There's lots of reasons consistent with innocence that could be told, but her reason better be one of those. Let's see. Kyle notes the 5-year platinum program. That's our higher level of membership. That's what gets you the My Legal Consult for free if you're involved in a use of force event. And we don't take outside consults anymore. We only do legal consults for our platinum members now, effective last year. We have an occasional promotion we do for a platinum member that brings it down to 82 cents a day. Let me see if I have a banner for that. I can't promise that this link works because this is only an occasional promotion. Here it is. So it's basically half off our platinum membership, and it provides you with every other piece of educational content, every course, every book in every form. So the book is in print, digital, audio, video form. The courses are in DVD and online streamed instant access form. It's a package that includes everything that we do, covers you for platinum membership, my legal consult for free. When we took outside consults, we charged a minimum of $10,000 for a consult. But now we don't charge anything because we only provide it to platinum members. They get it for free, covers you for 5 years, and the cost works out to 82 cents a day. So if that's of interest, you might try the URL. I'm not sure it's going to work, but because I don't think we're running the promotion right now. We're not supposed to be. It's not on my calendar, but maybe they forgot to take it down. So you can check that out at lawofselfdefense.com/82 cents. Okay, back to the questions. Let's see. Clay notes, it's not the gas, it's the fumes that explode. This is from the first video with the prankster pouring purported gasoline on the hood of the cars. If you smell gasoline, you're in the fumes. Fair enough. I mean, it becomes kind of a fuel air explosive, right? Tony asks, off topic, but can you explain Chevron deference and the rule of lenity? Well, Chevron is not a use of force doctrine, but so it's not my area of expertise, but just, general legal knowledge. Chevron was the Supreme Court case in which the Supreme Court essentially said that if there's an administrative decision by part of the executive branch, the EPA makes some kind of administrative decision. It's not a statute passed by the legislature, by Congress, signed by the president. It's not a law in that sense. It's not case law. It's not an appellate court ruling. It's just the EPA makes an administrative decision that is treated much as if it were a statute or was case law and is equally binding. The effect is to give the administrative state, the bureaucracy, incredible power and authority that many argue, I would argue, they should not have. They should not be able to create law as an administrative agency. And Chevron deference refers to that Supreme Court decision that said basically that the courts, the federal courts, are going to defer to those administrative agencies in their decision-making, which I think is absolutely terrible policy. The rule of lenity applies in many contexts, including the use of force context. And basically it says if a criminal statute is ambiguous, there's two ways or more than two ways of reading, interpreting that statute. And it's being applied to a criminal defendant. The criminal defendant gets the benefit of the most favorable interpretation of that statute. Leniency, the doctrine of lenity. Because the defendant didn't get to draft the statute, the legislature did that. And if they did it in an ambiguous way, that should be held against the legislature and in favor of the defendant. That's the doctrine of lenity. Jeffrey says, I really need to bring a notepad when watching these shows. Well, you're a member, Jeffrey, so just, every show is kind of a fire hose of information, but if you just, one of our goals here is to provide our members with a constant exposure to this use of force law so that you absorb it more or less by osmosis. If you listen over a period of weeks or months, you'll hear me say much the same things over and over again. So you get repeated exposure. And it just becomes second nature with repeated exposure. It's a really important part of making yourself hard to convict. You do, of course, you need to learn the law of self-defense up front. That's important. But if you learn it just once and you don't maintain your exposure to the concepts, it goes away. It certainly won't be, the knowledge won't be actionable in the heat of the moment, in the crisis of the moment when you're making life and death decisions. Just like if you took a weekend pistol course, that's great. Take a weekend pistol course. They're great fun. I love them. But if you take that weekend pistol course and then you don't touch your pistol again for months, all those skills you may have acquired over the weekend are gone. You have to maintain those skills. You have to dry fire, etc. The same is true of having this use of force law information that I share with all of you actionable. If you're not a law of self-defense member, you're not getting constant exposure to these concepts, the knowledge just goes away and isn't available for you in the crisis of the moment. So a big part of what we do here at Law of Self-Defense is facilitate your ability to maintain this knowledge in an actionable way. Let's see. Oscar says, question, how does my age condition as a 71-year-old man, open heart surgery 18 months ago on blood thinners, factor into elements of reasonableness, avoidance, imminence in self-defense? How to frame a narrative that I likely cannot survive a punch? Yes, so a phrase you've probably heard is that the use of force narrative has to be considered in the light of the totality of the circumstances. So whether your perceptions, your decisions, your actions in self-defense were reasonable, one of the elements of self-defense is considered both from a subjective perspective, reasonableness, subjective reasonableness, your genuine good faith belief in the need to act in self-defense as you did, but that alone is not enough. That belief also, that subjective belief also has to be objectively reasonable, meaning a theoretical, reasonable, and prudent person, the legal phrase, would have shared that subjective belief. So your subjective belief can't be speculative or irrational, for example. It has to be objectively reasonable. But that hypothetical, reasonable, and prudent person, standard, that second half of the element of reasonableness is customized for you. It's customized on your physical abilities or disabilities and specialized knowledge, for example, that you may or may not have, personal knowledge that you may or may not have. And a big part of that in the context of Oscar's question is your physical state. So a punch that may be harmless, well, not harmless, a punch that may not reasonably represent a deadly force threat to a healthy 25-year-old, 200-pound male may represent a deadly force threat to a 71-year-old who had open heart surgery and is on blood thinners. Those are two different people. The same punch can have completely different effects on them. So that's the question. Was the threatened force, the unlawful force, is it reasonably likely to inflict death or serious bodily injury? When that punch is inflicted on the healthy 25-year-old, 200-pound male, probably not. It's unlikely. It's possible, but unlikely. When that identical punch is inflicted on a 71-year-old who's on blood thinners, yeah, pretty likely it can inflict, if not death, certainly serious bodily injuries. And if you're on blood thinners, a blow to the head can inflict death very easily. So does that mean the healthy 25-year-old and the less healthy 71-year-old can respond differently to the same punch? Yes, if you can credibly argue that the punch represents distinct levels of threat to each of them. A non-deadly force threat to the 25-year-old, so he can only respond with non-deadly defensive force, but a deadly force threat to the 71-year-old, so he can respond with deadly defensive force. And that's how you would have to phrase your narrative of innocence, your narrative of self-defense, if you were that elderly defender. Let's see. Richard says, by taking law of self-defense classes and listening, my entire mindset perspective has changed considerably. There are many things I would never now consider. Well, good. That's our goal. That's our goal. We want all our members to be able to act decisively in self-defense, to be able to decisively defend yourself, your family, your property in self-defense. And part of that is informing you on where the legal boundaries are so you know you're well within them. That helps you act decisively. You've thought through the legal dynamics long before you find yourself in the physical confrontation, and you've kind of hardwired in your defensive responses to know that they're legally sound. So you don't have to think through that part of it when you're in the crisis of the moment. And by the same token, we help to, because you've learned where the legal boundaries are, we've helped you avoid using force outside those legal boundaries when you're really vulnerable to a justified conviction for your use of force. So we don't want that to happen. And we want you to be we don't tell people what to do at Law of Self-Defense. We don't tell you when to use force, when not to use force. Different people are going to draw that line in different places. That's up to you to decide for yourself. We do want to help you make informed decisions so you know the risks you're incurring. Jeffrey says, I'm listening to older shows at work every day for 4 hours till my phone gets low and can't recharge during the day. Yeah, folks, we have, for our Law of Self-Defense members, we have thousands of hours of video, podcast, God knows how many words. It must be millions of words of content. That's just on our website for our Law of Self-Defense members on all these cases, going back well over a decade. All right, I think those are all the questions. Oh, I did want to share a third video. So I have this third video. This one will be very brief because I don't have a lot to say about it. It involves police officers attempting to make an arrest of an individual without much luck. So yeah, sorry it's so small. It's really a vertical image. It just came across my my Twitter account this morning. So it's hard to see because everyone's in black, but the suspect's in black, and believe it or not, there's 3 police officers. You'll see the third one in a moment. He's on the ground here behind the suspect, and they're physically fighting with this suspect to get him in control, and they can't do it. He escapes their grasp. There's a car, that car right behind them there. The suspect will make it into the car. Presumably it's his car, because he'll start it up and drive away. He'll make it into the car. They'll tase him repeatedly with tasers, and they still can't control him. And then he just drives away. So let's take a look at this video. It's only about 30 seconds long. I'll get up in a moment. There he is. There's a suspect. There it goes, gets in his car. You'll hear the tasers. There's one. Another. Another. And off he goes. By the way, that escaping suspect in that vehicle, is that a deadly force weapon in his hands? You think he's driving responsibly, or you think he's driving recklessly, representing an unjustified risk of death or serious penalty? You think he's going to be running lights to get away from the cops, to avoid the arrest he just fought to avoid? Yeah, I would argue that's a deadly force threat, just him driving away. When he gets access to his vehicle, is that a deadly force threat? If he doesn't have weapons on him, where do you think he's likely to have weapons? Inside his vehicle. That's why cops will take you out of your vehicle if they have reason to suspect you're a bad actor, more than just a mere routine traffic stop. If they have reason to be concerned that you might represent a threat to them, they pull you out of the vehicle. These tasers, repeated taser hits. Folks, when tasers work, they're a wonderful thing. People just lock up, fall over, like a falling tree in the forest that's been chopped down. But a lot of times they don't work. The needles don't get good contact. And then it's a pointless exercise. Now, I'm glad cops have them, I guess, because when they do work, it saves the cops from having to shoot somebody while securing the arrest. It's good to have non-deadly force options on the belt, so you don't just have to go to the gun. But man, those tasers, they fail to work an unbelievable percentage of the time. And it's even worse if the suspect knows how to defeat a taser, because there are specific things you can do to make it less likely that the darts will get good contact. But what are these cops doing? Taser, 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 no effect, nothing's happening. And I expect what's happening here is that they've been told by their bosses, and of course, they've been informed by trials like the Derek Chauvin trial, by the Kim Potter trial, that if they escalate force, even if it would be lawfully permissible to do that, they're creating enormous legal risks for themselves, potentially spending the rest of their lives in prison. So that deters them from using the force that arguably they should be using from a tactical perspective to secure this person's arrest. They just won't do it. They'd rather let him get away. Because guess what? If they end up charged, if this person ends up dead and they end up charged with murder, manslaughter, like Kim Potter did, what did the prosecutors argue in the Kim Potter trial? As wrongfully conviction as I've ever seen, by the way. What did they argue in the Kim Potter, the taser trial, where she thought she was about to tase Dante Wright, and instead she unintentionally pulled her pistol and she shot him with a 9mm round, fatally wounding him. What did the prosecutors argue then in that case with Kim Potter? They literally argued, well, you could have just let him drive away and arrested him later. You think the prosecutors would say that here if they managed to kill this suspect and the prosecutor wanted to charge them with a killing crime? Sure. You think these cops are familiar with the Kim Potter trial? I bet they are. So we've deterred our cops from using what would be legally an appropriate level of force because of the consequences that follow, that they have to be concerned will follow. if they use a tactically appropriate level of force to secure an arrest. But the real reason I wanted to share this video with all of you is to, because most of you are not police officers. The real reason I want to share this video is to provide an example of 3 large cops using their physical strength and tasers to attempt to compel compliance of a single suspect. And there doesn't appear to be any other people around. There's no crowds to worry about. They could focus all their energies, their physical energy and their tasers on this one suspect. 3 cops, presumably 3 grown men, and they weren't able to do it. They, professionally trained in these techniques, provided with these tools, these non-deadly force tools, were not able to compel the compliance of the suspect. That should inform all of you about your prospects for compelling compliance in a disparity of numbers scenario. So you're faced by 3 bad guys who intend you harm. You have reason to believe they intend you harm. A forcible felony of some sort. That's a reasonable perception of an imminent threat of unlawful harm by this group of 3 aggressors. What prospects do you have of compelling them to leave you alone using only your physical strength or using only non-deadly force weapons when 3 cops couldn't subdue a suspect? So would this suggest to you that if you're facing a disparity of number scenario, maybe going to the gun would be legally justified because you can't defend yourself against 3 people? The only reason it happened here was the cops were not allowed to go to deadly force. All right, one last look at the member questions, and then we'll wrap up. Let's see. Somebody says, Clay asks, what's your opinion of the new pepper ball guns? I saw a demo for a local police force. I was pretty impressed. So there's a company, I think it's pronounced Byrna, Byrna, I think is the company. I did a whole show on Byrna, by the way. And they produce a device that looks exactly like a pistol. And it fires pepper spray, but not in spray form. It's like a paintball gun. It's a pellet that bursts on impact. You're firing these pepper spray balls, and it's intended as a non-deadly defensive weapon. And I have to say, I'm not a fan. I'm not a fan of the Byrna device because of the risk of misperception. If you point what appears to be a real gun at someone, and the Byrna guns, I know they come in fancy colors like bright orange, but they also come in black. The last time I looked, it looks just like a real gun, folks, from any distance. If you point what appears to be a real gun at someone, are they allowed to treat it as a real gun, even though it's not, if it reasonably appears to be a gun? Yes. Now, if you're using pepper spray to defend yourself, presumably it's because you believe only non-deadly defensive force would be appropriate. Otherwise, you'd be going to your gun, right? I'm presuming we're talking in the context of you live in a place where you can have a gun on your person for personal protection. The argument's a little different if you're in one of the hard gun control states. But if you're in a place where you have a gun and you have a Byrna, and you're using the Byrna, it's because you don't believe the gun's an appropriate defensive measure. You don't believe you're facing a deadly force threat. So that's why you're going to the Byrna. So you're being threatened with non-deadly force. Someone's threatening to punch you under circumstances where a punch would not reasonably be perceived as a deadly force threat, and you're using non-deadly force in self-defense. Would I be prepared to use pepper spray in that circumstance? Yes, of course. I carry pepper spray every day, just like I carry a gun every day. Precisely so I have a non-deadly defensive tool in my toolbox to use when facing a non-deadly force threat, because going to the gun is not likely to be a lawful option if you're facing only a non-deadly force threat. So I'm a fan of pepper spray generally. The trouble is, if someone's threatening you with a punch and you pull out what appears to be a gun and point it at them, in their reasonable perception, you've just escalated what was a non-deadly force threat to a deadly force threat by pointing a gun at them. Are they now permitted to pull their own gun and defend themselves against your deadly force escalation, even though they started the non-deadly force fight? Yes, they are. And what if they pull out a real gun while you're pointing a burner at them? That's not going to end well. You know it's a burner. You know it's only non-deadly force, but they don't know that, and they're allowed to rely on their reasonable perceptions of the threat you're apparently presenting. So if the burner device, I don't have a trouble with it throwing the little balls of pepper spray. That seems pretty neat to me. You probably get a lot more distance. Although why you're using pepper spray at a greater distance, I don't know. Again, presumably you're only using it against a non-deadly force threat. How distant can you credibly perceive a non-deadly force threat? But setting that aside, the fact that the device throws a ball of pepper spray, I don't have a particular problem with. But the fact that it looks just like a gun, I think is problematic. It would be nice if they had a version of it that didn't resemble a pistol quite so much, which is awkward because, pistols are shaped the way they are for reasons. But so I'm very hesitant about that. And by the way, when I did my show on the burner pistols and I shared this opinion, I pretty much immediately got a message back from the CEO of Byrna who was extremely unhappy with me. But listen, I'd be happy to have him on as a guest and share his point of view. He wasn't able to respond, to my mind, to any of my concerns with the device. Now, if you live in a jurisdiction where you can't carry a gun, they make it effectively impossible for you to carry a gun. So a gun's not an option for you. And all you have is a Byrna. Might it be a more reasonable defensive option? I don't know. I still have the same concerns about it being misidentified as a gun. By the way, if you're spraying someone with pepper spray and a cop turns the corner and it's a pepper spray canister and he sees you spraying someone with pepper spray, is he likely to perceive that there's a deadly force interaction taking place? No. But if he sees you pointing an apparent gun at somebody, might he think you're about to murder somebody with a gun and shoot you to prevent that from happening? Maybe. So those are the concerns I have with the Byrna pistol. Let's see. Mike says, I'm a retired cop, and for the sake of these police officers, I'm very glad the guy escaped. Yeah, I'm not suggesting the police officers in that last video I showed where the 3 cops were unable to subdue the suspect. I'm not suggesting they're making bad decisions, especially for themselves personally. They may be making extremely prudent decisions for themselves personally. I guess I would ask the question, is this good public policy to discourage cops from escalating to tactically reasonable force in subduing a criminal suspect? That's not, cops don't get to make public policy. So that's not on them. They're responding to the public policy dynamics that are imposed on them. But we as a society, we vote, we elect mayors and police chiefs, and, we're not going to get a less violent world by, I would suggest we're not going to get a less violent world by overly constraining the privilege of police to use force in making a lawful arrest of a criminal suspect. Let's see. Paul says, comment for the group. The Florida new law concealed carry without a permit. So Florida became, I guess, kind of a constitutional carry. Still makes you liable to be charged with a felony when traveling through a gun-free school zone, and there are thousands of them. You still should have a concealed weapons Florida license to avoid that charge. So this is a gun law question. I don't really do gun law, folks. I will note that if what Paul's referring to here is the federal gun-free school zone law, the way that statute is phrased, it makes it a federal crime to have a gun in a school zone. As I recall the language, and, again, I don't do gun law, so you should look this up yourself, but just as a point of interest, it makes it unlawful to have the gun in the school zone unless you have the permission of the state to have the gun. Now, this law, this federal statute, was written at a time when very few states had any provision for people to be lawfully carrying a gun around. I would suggest if you have a concealed carry permit, that's your permission to carry the gun. So the federal gun-free school zone law should not apply to you. And I would further argue that if the state now moves on to constitutional carry, they've created a universal privilege to carry a gun, unless you're otherwise prohibited, of course, in which case, again, you have the state's permission. So again, I don't think the federal gun-free school zone law should apply. But again, I will defer to genuine experts in gun law on that question. But that's what I would ask those experts about that exclusion from liability under the federal gun-free school zone law, how that would apply in the context of gun permits and constitutional carry. By the way, I'm speaking to the federal law. There are many states have similar laws. So when I lived in Massachusetts, even with a concealed carry permit, you couldn't carry on school property. And even if you were a police officer, if you were not on duty, say you were attending night college, so you're on duty during the day, but then you're off duty, you're attending classes at the college, you could not carry your duty weapon on the college premises without written permission of the college in Massachusetts. So that was the state level prohibition independent of the federal law. All right, folks, those are all the questions. I am all caught up. So, oh, listen, a couple things. One is I'm this close to 70,000 followers on Twitter. If you use Twitter as a social media platform, please give me a follow. It's at Law Self-Defense, at Law Self-Defense. It would be great to hit 70 grand. I'll do something special as a show if we hit 70 grand. And the same thing for YouTube. I'm this close, 49,000 and change subscribers on YouTube. I'd love to hit 50,000. They don't send you a plaque or anything for 50,000, but it would be a nice milestone. And again, I'll do some kind of special show, maybe a tie-less show if we hit 50,000 on YouTube. So if you use YouTube, you watch our content on YouTube, or even if you're a Law Self-Defense member and you watch on the member dashboard, but you also use YouTube, go to youtube.com/law of self-defense and subscribe to our channel. Push us over 50,000. That would be fantastic for all of you to do. I would really appreciate it. And with that, folks, I will wrap up today's show. Just remember, if you carry a gun, if you own a gun, if you have pepper spray, if you learn BJJ, if you do anything to prepare yourself to defend your life, your family, your property from criminal predation, well, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.